gentlemen of the media, good morning and welcome to the Attorney General's first press briefing for the year 2017. Of course, I take this opportunity, we're a bit late in January, but Happy New Year to you all. The press conference comes at a time when the Attorney General is preparing to head to Kingston, Jamaica for the CLE meeting. Of course, the Attorney General and Legal Affairs Minister, the Honorable Basil Williams, will read the statement.
Thank you, Malika. Good morning, ladies and gentlemen of the media. Of course, it's my first press conference, 2017, and so I must say I'm happy to see you all here today. Our press statement is captioned Council of Legal Education's meeting of the Executive Committee. The Honorable Attorney General and Minister of Legal Affairs, Mr. Basil Williams, SC and P, is due to attend the Council of Legal Education's meeting of the Executive Committee to be held in Jamaica between January 27 and 28 of 2017. Among the agenda items will be the establishment of the J.O.F. Haynes Law School of the Americas, for which a memorandum of understanding was signed by the government of Guyana and the University College of the Caribbean, UCC/Law College of the Americas, LCA, on January 11, 2017 in Guyana. The Honorable Attorney General is expected to partake in a press conference and reception in furtherance of a program to sensitize the Jamaican public on the establishment of the law school in Guyana. Meanwhile, Mr. Anil Nandalal of the PPPC has written the Council of Legal Education maliciously, seeking to prevent the establishment of the law school in Guyana. Guyanese had long suspected that Nandalal and his party, the PPPC, had no interest in the welfare and well-being of our University of Guyana law graduates and the travails they suffer to enter and study at the Hugh Woodin Law School. The Honorable Attorney General is confident that the corrosive efforts of the opposition cannot stop an idea whose time has come. Special prosecutors. 6 special prosecutors appointed by Cabinet have been issued with fiats by the Director of Public Prosecution, Ms. Shalima Hack, to prosecute the case against Mr. Shabita Jagdeo and Omar Sharif, which is being tried in the Georgetown Magistrates Court. This is the maiden trial for the special prosecutorial team, whose members could only prosecute matters with the concurrence of the Director of Public Prosecutions, except, of course, where a private criminal matter is filed. In addition, the members of the team are assisting the Special Organized Crime Unit, SOCU, in its preparation of cases to be prosecuted. This ends our statement.
Thank you, A.G. Ladies and gentlemen of the media, you can now feel free to pose your questions. I know there may be a number of those in light of everything that's happening regarding this sector. However, the Attorney General has about 30 minutes, so please choose your questions wisely. Identify yourselves and the media house that you represent. First question, please.
A.G. Dennis Shabaldam, sir, could you say which aspects of Mr. Nandal's letter to the Council are you objecting to? And also, can I seize the opportunity to ask, to what extent do you believe that the out-of-court settlements, well, of course, the one in particular with DDL, has resulted in a similar case by Banks IH, and perhaps if you believe that the government had erred in settling the matter with DDL out of court?
Yes, well, let me take the last question first. The DDL matter, of course, is an inherited matter, and it was not inherited by the Attorney General. The matter is a matter against which an action was filed by DDL against the GRA, the Guyana Revenue Authority. Now, the CCJ has held that the Guyana Revenue Authority is an independent institution and not a government department. So the Attorney General, whose remit is to represent the government departments, and different aspects of government sector, ministries, etc., would not come under that. And that's why that case, in fact, was being handled by GRA, and I think their counsel was senior counsel, Mrs. Stobie. So it's not a matter within my jurisdiction. And I'm not in a position to say whether it was proper or not, but in settling matters, there are many different considerations, and I would trust that Senior Counsel Stobie had the right and proper considerations uppermost in his mind when he and the GRA team dealt with that matter.
The first question in relation to what aspects of Mr. Nandala's letter to the CLE do you find objectionable?
Well, I haven't seen the letter, but I have been informed by the chairman of the Council of Legal Education, Senior Counsel, Mr. Reginald Armour of Trinidad and Tobago, that he has done so. And in fact, the matter, as I indicated to him, the matter will be addressed at the council meeting. It will not be a substantive agenda item, but it will come under any other business. I'm not sure what Mr. Nandal is trying to achieve. He must know that the council had years ago given permission to establish a law school in Ghana. His government didn't get it done. In fact, all the problems that our law graduates are facing right now from the University of Ghana, they have to lie at the feet of the PPP. They stopped paying any contribution to the UWL Law School since 2002. And so the limited numbers of what we had said hitherto should have been Guyanese law graduates were watered down by UWL Law School. They were saying it should be 25 law graduates of the University of Ghana. And they knew that we have Jamaicans and Belizeans there. So it would have, in fact, if that had obtained, it would have meant that there was only a few Guyanese out of nearly 110, 20 a year would have been able to enter into UWL Law School. And so we met that situation. I inherited that. There were no documents left in here except for few in relation to the Council of Legal Education and the law school. I said that for when I came in as minister. And we met the failure of the last government to sign an inter-collaborative agreement with UG, UE, and the Council of Legal Education with respect to the tenure and the access to UWL Law School by our graduates. You know, my first year, I actually had to make contact with the President and the Foreign Minister at the heads of government meeting, and they were able to get the heads of government to amend its agenda and include the plight of our law graduates, and they were able to enter. And in the second year, when we thought that that was enough, they practically increased the fees, you know, very substantial amount. Almost making it prohibitive for ordinary people to actually study there. And a lot couldn't take up their places in the first 25. And I was able to, in that regard, speak with the council, speak with the UWL Law School, and get them to not ask all the money up front, but to stagger the payments over the academic year. So we couldn't continue like that. And that's why the government gave the go-ahead to explore the establishment of the Jagdeo Law School in Ghana in collaboration with a joint partnership. It's a private partnership venture with the University College of Jamaica, an established college in Jamaica. And their graduates also would be able to access this law school in Ghana. And that's where we are right now.
H.E., could you allow me a follow-up, please?
Sure.
It's a very important one. Sir, I note you pointed to the CCJ ruling with respect to there being an autonomous body and so on in relation to the DDL matter. But sir, more than $20 billion could potentially be drawn from the national coffers to settle the bank's IHKs. Shouldn't this be gaining the attention of the Attorney General, some sort of analysis as to the implications on how this could be avoided?
Well, as I said, even this morning there was a team from the GRA, a team of GRA's lawyers here, and they consulted with my staff because I wasn't here at the time. And I'm in fact working on the other case, the SM Jalil case, which you know, the SM Jalil company and the Ghana Beverage Inc., their local company, had piggy bank on the Rhodesia's case. And many other people, many other companies have signaled that as a result of the Rhodesia decision, which they claim to have mirrored facts with their situation, that they intend to address the same issue of being reimbursed for the taxes paid under the unlawful regime created by the last regime, where they passed legislation in breach of the revised Treaty of Chaguaramas. All these problems we inherited, and we are trying to work with them and try and see how best we could settle it.
But do you believe that it should be settled out of court in light of the potential?
Well, as I said, I don't have custody of the case. In fact, I see they sued me, and since we're talking about not being the proper party and all of that, I'm not the proper party in the matter against GRA. I see some newspaper that has good lawyers actually did the right thing and said the GRA was the proper party to be sued. And of course, I will give all and any assistance that is necessary in protecting the government's coffers, the taxpayers' coffers. We are very confident that the case will be a proper case. Because you must always remember in tax matters, there's a statutory limitation. You can't sit on your rights and hope that the cost will keep increasing and keep increasing, and then you come 10 years later. You have 3 months within which, if you overpay in tax, you have 3 months within which you must bring an action. But that's all I want to say. At this time, I don't want to interfere with Mrs. Toby's case.
Next question, please.
Mr. Williams, could you respond to concerns?
That is how the chair is? How you sitting?
It's very good, but anyways. The Basil Salmon from the Ghana Times, could you respond to concerns that that you and your government is attacking the judiciary? And with regards to the law school, could you explain how the zone will be working for the jail and youth law school?
Well, in terms of zoning, you know, you have in the Caribbean itself 2 zones you would in law school, that deals with Ghana, Trinidad, and the other islands in the OECS, St. Lucia, Antigua, etc. And normally deals with Jamaica and those Bahamas and the other islands down in that area. Ghana is in South America, as you know. That shouldn't be a problem. As I said, they're given permission for us to open a law school in Ghana. The last government didn't see it fit to complete it. So, but we will do it. We have to do it. As you see the dire straits of which our students are.
So therefore the law school will be open to people?
Everybody in the region.
Okay.
It will be open to.
And the concerns about the judiciary?
Well, let me say this. There are 2 aspects of this. I see they're attacking me for attacking the judiciary. I don't know what I've said. All I've said in relation to the 2 cases is that we will appeal the 2 cases to the CCJ. I'm not sure how they're confusing Maxwell Edwards and other people's opinions with mine. I know Maxwell Edwards used to be one of the Chancellor's magistrates. I think he was treated badly by the Chancellor, according to him. And you could see that he is a man that is hell-bent in ensuring that what is happening with the judiciary is made known to the world and the country at large. But for my part, I don't have to do anything because the Chancellor himself established a precedent in the case of the Acting Chief Justice Chan last year. If you recall, at a press conference I was asked about Mr. Chan's tenure, and I mentioned that he was supposed to demit office on the 23rd. They actually shared the same days. But in terms of whether he would go on pre-retirement leave and all those things, I wouldn't have that particulars. The chairman of the JSC, who was the Chancellor, had that. And the Chancellor card saying, give me the particulars for Mr. Chan. And that's how I was able to, we were able to determine, because of the advice given by the Chancellor card saying, Acting Chancellor, when Mr. Chan had to leave office on pre-retirement leave, and when he had to demit office entirely on his birthday. So the Chancellor, who's chairman of the JSC, he supplied me with all that information. So it will be strange to me that having done that in the case of Acting Chief Justice Chan, in his case, that it would be different. I would expect that the Chancellor would also proceed on pre-retirement leave and then leave on his birthday, as he had asked and advised me that should be the position of Acting Chief Justice Chan at the time. So there was no need for me to make any noise. In fact, I've seen the writers, they have their own information. I benefited from reading the information, say that is true. But I didn't need to do that because, as I said, Chancellor Singh himself established that precedent. And in terms of Mr. Jagdeo and Mr. Ramkaran's attack that we interfere with the judiciary, let me say this. It was under the tenure of Mr. Jagdeo that our judiciary was emasculated. Our judiciary, you recall, the powers were removed from the Chief Justice Office and reposed in the Office of Chancellor. And then what they did was, whenever there was a meeting of the opposition leader and the president to determine who should be Chancellor and Chief Justice, Jagdeo always asserted Carl Singh to be the Chancellor. Why? Because he prepared the wicket, he removed all the powers from one office to the next. And let me say, it is important that there's a dichotomy between the Chief Justice's functions and the Chancellor's functions in terms of sharing the work in the judiciary, so that one person alone will not be in charge of the entire judiciary and administratively. And that has affected us a lot, a great deal, because it meant that when the Chief Justice had supervision over the judges of the High Court, and the Chancellor had supervision over the judges of the Appellate Court, and I think the magistrates, we have a situation where the check and balance that we had was removed. And so you actually had the Chancellor appointing from day one who should be the magistrate, who should be the judge, and who sits in the Court of Appeal. How could that be healthy? It means then that at the end of the day, he would be sitting on appeal of decisions made by people he had actually handpicked to sit in cases. And that couldn't be well for the administration of justice. And so not only that, there are other things that we found happen under the Jagdeo watch. Our constitution is premised on the separation of powers. That is, the judiciary, the executive, our government, and the legislature. They all have their independent roles, and no one should tread on the work of the other. What we have on the Jagdeo was that we had a marauding judiciary. So the complaint is not that there's interference with the judiciary. The judiciary on the Jagdeo was interfering in the work of the executive, and that is happening till now. And where was Mr. Ramkaran, who was part and parcel of that? You ever heard him making any objections there? How could it be possible that in an independent executive office, that is the Deeds and Commercial Registry, that has an act that establishes a board, they have the independent board, they earn their own revenues, they pay their own salaries, they recruit their own staff, they contribute on average almost 400 million each year to the consolidated fund. How do you explain that without let or hindrance, the JSC could send in the top 2 persons without consulting the board or consulting the minister responsible for the registry? So that's where you have the judiciary overreaching. And I will say this again, we will correct it. The judiciary cannot be concerned with the offering of legal services in Ghana. The judiciary cannot be concerned with transports, fees for transports, fees for deed of gift, fees for power of attorney. That's the work of the registry. Only the executive could offer legal services. And so you see clearly how dysfunctional the judiciary was made on the Jagdeo. It has chronic backlog of cases. We inherited a dysfunctional judiciary, so I don't know what Jagdeo is talking about. Are we going to correct it? And that's what we're trying to do, and there's nothing that you you know in no part of the world where you have to effect change, that the persons who benefited from the old system will not put up a resistance. They will. And that's why you have to, as I said to our government and my colleagues, be strong and of good courage.
There's always a phrase to start with me. Hi, AG. The first question has to do with special prosecutors. A couple of weeks ago in the Ghana Chronicle, 6 names were mentioned. Could you confirm if these are the persons who would be appointed special prosecutors for the Jagdeo matter, and whether or not you're looking at any other person? And secondly, with regards to anti-money laundering, given that Guyana is no longer in danger of being blacklisted, you said the focus now would be on the successful prosecution of cases. You would also propose that persons be trained to prosecute money laundering cases. Could you say how that is going? And with regards to the FIU, a director and a deputy director, they were identified. Have they been appointed, or are other persons being considered for those positions?
No, they have been appointed a long time now. They were appointed by the process in Parliament, and they are on the job. The director has actually attended a CFATF conference with me, where we were removed from the CFATF list, and the other processes, we were cleared. And so they are aboard, and they're working. And they're part of our compliance team also. We have to widen the compliance team. We will have to include SOCU head, the SOCU head on that compliance team. He has to start attending CFATF meetings. And also we have to get a representative from the Bank of Guyana. So we need to widen that. You would have noted that I have appointed a special advisor to deal with my AML CFD and to assist me in my responsibilities, because I'm now deputy chair of CFATF, and God willing will be chair in November when the CFATF conference is supposed to be held here in November too. And so you would need somebody. In fact, I'm following the precedent of the Trinidadian Attorney General, Faris Alwari, because he had to appoint a special person to actually dedicate themselves to deal with AML and CFT matters and FATF, CFATF matters. So I took his advice.
Training for money laundering.
Well, as you know also, Zoysa, that a Mr. Alex Ferguson was here recently, and he conducted training in that regard, and those prosecutors were there. They attended that session. I'm not sure if Mr. Compton Richardson, very senior, very experienced prosecutor, I'm not sure if he attended. He might have attended. When I was there on the opening day, I didn't see him. But those are people. And in terms of future prosecutions, they obviously, I don't wish to disclose now what these prosecutions prosecutions are and what would be onboarded, but you see as they evolve.
And Prattville too?
That includes Prattville too. We'll indicate when the time comes.
The 6 persons.
You see, also you have to be careful with how you deal with matters, because already we had the Honorine taking flight out of Ghana. And so we also have to look at measures to ensure that persons who have filched the taxpayers' money from this country and state assets are not given a heads up, so that if you flee the country, and we could tell you billions of dollars are owed. And that's why we are on board in SARA in Parliament, and that SARA bill is going to be a very effective bill. And you must remember that it is a bill that comes under the International Convention against, United Nations Convention Against Corruption, and also the Inter-American Convention. All the provisions come from there, because the entire world is engaged with this whole question of filching state assets and people empowering themselves on the state assets at the expense of the populace.
But sir, the 6 persons, the names that were listed, are those the persons who are going to be handling the part of the
I'm not sure why you want to know whether who specifically will handle it. in this particular case of Omar Sharif, even though all 6 have been given fiats by the DPP, it might not necessarily be that all 6 would be working on that. They are also assisting the head of SOQ in preparing prosecutions. And we also have identified persons from abroad who will come in certain matters, senior counsel too.
So, sir, are you saying those 6 persons are not specifically for the Carterville too?
I'm not saying anything. I'm saying that when the time comes, we will make that disclosure.
H.E. Duncan, I think is, the president, I think, would have delegated you to meet with a representative from the opposition to discuss the GCOM chairmanship, that understanding here. Can you tell us what to expect? And the Red House matter, that is in the court at present. Can you bring some clarification to that?
Well, let's take the former question. The president has ordered that the leader of the opposition identify someone to meet with his attorney general. The leader of the opposition, pursuant to that order of the president, has identified Mr. Mohamed Nandalal. He has written me and he's asking for any date after the 25th of January. So he, of course, knows that I have to attend the Council of Legal Education meeting. That's why he opted to write a letter and make contact with the chairman of the Council of Legal Education. And so it's clear if he's asking for that. In terms of when I received his letter, we could have had a meeting. But it will convey to me that there's no urgency at this time to have such a meeting. And so I don't wish to say anything else on that.
But do you have a date you're looking forward to?
No, we'll look at those matters when I return.
And the Red House? The Red House, the matters in the court?
The Red House matter was taken to court by the management of the Jagdeo Research Center, Inc. And you know, I have been on television, I have been in the newspapers indicating what the status is, that the building and the lands are national monuments and heritage sites and everything, so you can't alienate that without the permission of the Minister of Education. And secondly, the Commissioner of Lands and Survey could not have leased it also, because he would have had to have, even if he could have done that, he would have had to have the sanction of the President. And that is a question that we are looking, you know, Mr. Ramkran is coming out making these outrageous statements that are not foundation and fact, but he's not addressing the crying need for an explanation from the Guyanese people. As the leading firm that deals with land matters, conveyancing matters, how is it he signed a lease and profited as having the sanction of the President when it did not? And then why, in such a lease, being a long lease, at least more than 21 years, he knows that the Deeds Registry Act requires it to be passed as a transport, in the manner of a transport. What is passing in the manner of a transport? It has to be gazetted, so the world will know. It has to be advertised in national newspapers of wide circulation. And after, if no one, so that any Guyanese who wants to make an objection could file a notice of opposition. And if none is made, then they pass it in front of the court. So it's a transparent process. Then they're required to file it in the registry as a matter of record and annotations made. And I can assure you, I have the records. Nothing of the sort was done. So the leading partner in Cameron and Shepherd must explain to the Guyanese people how is it that he signed such a lease, knowing fully well that it would be void ab initio, invalid, and a nullity.
Before court goes, sorry, just remind me, we just have about 10 more minutes, so please choose your other questions. Right?
Yeah, Mr. Attorney General. Sir, with regards to the special prosecutors, could you say how the government decided on these persons? What was the rationale used to make specific things?
Well, you know, I don't discuss the internal matters of cabinet, but as I indicated to you, these are persons who are well qualified. We have prosecutors there. You have Patrice Henry, as you know, is a solid police prosecutor for many years. He got qualified. He's practicing. Mr. Lake, you know, was attached to, I think he did some attachment with the UPP. Of course, you know, Conter Richardson is a giant in prosecutions. So we have people who have been practicing at the criminal bar. So.
Are you confident that they will do well with these specific cases?
Well, I'm not sure what you mean if I'm confident that.
You can't be that big there, you must be bigger than a lot.
Well, we have to use, you must understand, you know, we have to use people who are willing and who are available and who have the skill set. You must also recognize that those 23 years that this country was subjected to, they were brutal years. They were brutal on the legal and profession because a lot of people could not afford to not to pursue their livelihood and take up pro bono cases. And you know, for you to learn and develop, you know, the access to the type of cases that will help build you. You know, you don't get that easily unless you're willing to take cases without payment. And it was brutal. It was a brutal 23 years. And basically, you have lawyers that were utilized by the last government. And the question is, could we use the same lawyers and have confidentiality and the like? And, even within my ministry, we have problems with confidentiality, the matters that involve the opposition. So, you know, as I said, these are the challenges that we have been confronting, and these are challenges that we will overcome, and the country will be a better place.
Tiffany.
Tiffany Rogers, Gina. There's been a series of sensitization on the new civil procedure rules. Can you say when they're expected to take effect?
Oh, well, that's another, you know, as I said, it's nearly a decade now we've been hearing about civil procedure rules. You had different permutations, different persons coming over 10 years. It's like the family court. Every year the family court was supposed to be established every year. So there were some peculiarities under the last regime with respect to the functioning of the judiciary that really leave a lot to be answered. Why is it after 10 years we are still talking about new civil procedure rules? And I believe it's only because I decided to take the bull by the horn, and after they said they were ready and with the new rules, and they asked me to leave, I decided that the proceedings they had previously over the years never really catered to state lawyers, because the Bar Association, you know, state lawyers cannot be members of the Bar Association. That's something we have to address again. And so the training, you hear somebody comes in, and then you get some lawyers, spattering of lawyers, and so that's what happened. And after I was forced to train the state lawyers in the new rules, now that we know these are the rules, you see that within a matter of a week or two, new trainers came in again. And so one of the things you must understand though is that as Attorney General I'm head of the bar, and even though we understand that the judges, we don't have a problem with the judges training themselves, but the judges really can't purport to train the members of the guidance bar without preference to the Attorney General. I think it's this lack of coordination that attended the judiciary under the last regime that has caused all the problems that we have. That's why 17 persons died in prison. If you had a coordinated justice system, 7 people would not have died in our prisons. And the IDB has spoken about that. The IDB has said to me that they would find it difficult to give me any money to deal with any question of removing the backlog of cases, because they give a lot of money to wipe out the backlog of cases. And you know from your last release what is the state with the cases. everything was dysfunctional under the last government. And so I don't know how the leader of the opposition could really have the temerity to attack this government, which is on the path of correcting all of those deficiencies. And so that's what we have, that's where we are.
We'll take one final question if there are any other.
I just have a clarification for Mr. Williams. Did you say, is it that all state lands being leased, they require the sanction of the president?
No, but I think you were confused by Mr. Nanala, who was confused.
Yeah.
Because he equated state lands and government lands.
Yeah.
They're different. State lands are converted into government lands when the president issues an order for, to the Commission of Lands and Surveys and his successors. They're the custodians, they vest the land, the lands are vested in them and their successors. And government lands really then take on the characteristics of private lands. And so the particular lease under Section 10 of the Land Department Act says quite clearly, because, and I'll tell you why, it says you must have the sanction of the president. Having vested the government lands being vested in the Commission of Lands and Surveys, it means then that he could go and execute a lease with Gordon Mosley. Give Gordon Mosley any amount of land. And Gordon Mosley won't necessarily know whether this is a valid transaction or not. Because as far as you know under the law, the Commissioner of Lands and Surveys is the custodian of government lands. The lands are vested in him. So the president doesn't have to sign on the lease. It's the commissioner will be signing on the lease. And what is it's not a landlord tenant situation. A rental agreement will have the leaser and you would sign as list. So you won't know anything until people come to, the police come to you and start questioning you about how is it your party to lease that didn't have the sanction of the president. And incidentally, that is an offense under the act and it's punishable by 10 years imprisonment. So poor God, I don't know how you would fare with one of my special prosecutors.
Thank you very
Which
much.
works for my attorney.
Thank you, members of the media.
That's right.
Microphones on? Let me Oh, that's good. I could put it with my here conference.